record reflect that both Supervisor Phillips and I are here. And there's a correction you needed to make for the agenda?
Yes, just
Miss-
so what,
You want to say it on the record?
for the next meeting, there is a special meeting scheduled for August 8th at, sorry, I think it's at 11. Is that correct? 11 a.m.? Okay,
I like 11 a.m. better than 9 a.m.
okay.
Okay. We'll start with item number 1. This is a PG&E presentation, and we have Tim Clinton, Senior Customer Relations Manager, with us today. Thank you for being here.
Thank you. Good morning. I wanted to say thank you to Monterey County and to Chair Alejo and Supervisor Phillips for having us this morning and giving us an opportunity to speak, and also for any constituents in the audience as well. My name, as you mentioned, is Tim Clinton. I work for the Business Energy Solutions team for PG&E, and we have a specific focus on large ag and food processing here in the Salinas Valley. The majority of my work is to support customers and help them navigate through our processes, as well as reduce their overall energy demands and through energy efficiency and demand-side management. Today specifically, I'm here to talk about the reuse of rural greenhouses in Monterey County and how we can best work together in getting them fully operational once again. With the passing of Prop 64, we've seen a dramatic but not surprising increase in the indoor horticulture space. As you're all likely aware, the initial uses of these greenhouse spaces were not very power intensive, many only using a string of light bulbs to allow access at night, possibly a boiler for heating, but all the other energy use was through the transparent roofs that they provided. Today is a very different story. The cannabis industry specifically has been using these same spaces, but the power demands from grow lighting and HVAC systems are more equivalent to a data center than they are the greenhouses of old. The energy infrastructure out there was also originally designed to support the original old greenhouse requirements, not these multi-megawatt facilities that we're seeing today. PG&E is investing heavily in modifications and betterment projects to improve our infrastructure. And that's, our substations, wires, poles, conduits are all being updated to support these new projects. But all of that takes time. The large infrastructure projects are also moving in parallel with open service planning projects that we have with some of your constituents, maybe even some of the audience members today. And the improvements we're doing now are in process because we have active customer applications with accurate demand data that allows us to correctly scope the need in a given area. We can only plan and build based upon the demand we're aware of. And due to the way that we're regulated, PG&E must have an open customer application or a project prior to improvements being even started. But all PG&E projects are completed in a first-come, first-served basis. As you can imagine, every job is someone's #1 priority, and we understand that. Our goal is to treat projects and customers equitably. We welcome this new energy load, and we're looking for ways to safely bring gas and electricity, or electric service to every applicant as quickly as we can. For us to do that successfully, though, we need your help, and we have specific processes for each step. If something's missed in the process, it can result in delays to a project. To help avoid that, we've created a new website called Customer Connect Online, or CCO. CCO allows our customers to monitor their projects and to make sure that it's progressing as expected and not stuck on a missed item. It also gives specific access to contact information on individual details, so you can call the right person if in the event that you need to. Ultimately, we really want these projects to be a smooth process for our customers. But in the event that there's a problem, we're also here to help. Let us know what's happening, and we can work together towards the solution. And if that comes from you or if it comes from constituents directly, we're happy to deal with that. Can you go ahead and advance to the next slide? Oh, actually, no, you're good. So on this slide here, it's just basically some resources. And the top one is to initially start a project. And that's a direct connect to that CCO application that I was mentioning. Also, the call center that deals with that's called our Building and Renovation Services team. The middle one is going to be on an in-process project. So we've got also the CCO link for any existing projects that we have, but also local service planning here in Salinas. And then the last one is a direct connection with me on getting in touch for any information on energy efficiency or opportunities to reduce demand. And that's all I have for you, sir. Yeah, if there's any questions, I'd be happy to field those as well.
Okay, Supervisor Phillips?
Do you know how many projects are in the queue, cannabis projects that are waiting to get the power to them?
You know, it's really challenging. I've got the supervisor for service planning here in Salinas that might be able to speak to that. But one of the biggest challenges that we have is that typically when a project comes through, it doesn't specifically mention that it's for cannabis. It's just for new load. And so a lot of what we're trying to do is partner better with the county so that we've got an idea of what what permits are in place, and so that we can actually manage those as well. But they vary in size, and it's just very hard to track.
Okay. And I really do appreciate that you and we can't favor one business over another business in the time restraints.
Sure.
Do we have a general idea from the time that someone said, I need upgraded service out here, what's the general time?
You know, honestly, it really depends on the load. If you were saying, a residential load of 100 amps, that's a fantastically different question than 4 to 6 megawatts. And unfortunately, due to the way that we've structured this, the rural greenhouses, they just didn't have the infrastructure in place to be able to support the massive load that these things are taking, and they tend to be coupled. So there is, as you're both probably very aware, there's lots of locations where it's not just one greenhouse, it's many. And so, that it's not just 4 megawatts, now it's 12 or 18. And so that can really, change those numbers significantly, just because there is a lot more that comes into play with those. But we can get the information for you if you'd like. Yep.
I guess the difference for the cannabis industries versus the other one is they're on a kind of a timeline that they have to get up and running by X period of time, or they're out of compliance. If they can't get power in soon enough, then what's the alternative? Can they do it with bringing in a mega generator?
We've seen that on a number of occasions, actually. Yeah, whether it's liquid natural gas or diesel or other things. There's also other regulating agencies, like the Air Board and such, that also have a say in that. But yes, that would potentially be a possibility.
Thank you.
Mm-hmm.
Yeah, and I thank you for your presentation today, because as we have a new and growing industry in Monterey County, I think it was important for us to connect with PG&E and just see what the utility companies' plan were to address this in a timely manner. I mean, the demands in some of these counties that are I guess the top growing counties in the state. I mean, there's a different kind of demand, a new demand there than other counties throughout the state. So for us, in order to have a successful and robust industry, an important part of that was being able to get connected in a timely manner. So it's good to know that these resources are available, and hopefully that we could have that kind of dialogue, direct dialogue with PG&E as we try to troubleshoot when we're seeing perhaps some of these projects getting delayed. I think that's, and Supervisor Phillips answered the questions I had as well, so I thank you for being here. Anything else? Want to open it up for public comments on this? Is there any members of the public who would like to make any comments on this item, PG&E's presentation? See none? Thank you very much, sir, for
Thank
being
you.
here today.
Thank you.
Thank you. We're now moving to item number 2. This is a retail setback. And we have a presentation by Craig Spencer of RMA Planning.
Thank you, Chair Alejo. Good morning, supervisors. My name is Craig Spencer with the Resource Management Agency. Here with me is Brandon Swanson, also with the Resource Management Agency. We are here today seeking your direction on a draft ordinance amending the setback requirements between commercial cannabis retailers or dispensaries. As you know, this item's come before you, and right now the county's code requires a 1,500-foot setback between cannabis retailers in the unincorporated areas, and that limit was established when we originally adopted the regulations. It was intended to avoid a overall cap and to limit the number of dispensaries to commercial zoning districts and to cap by zoning the overall number of dispensaries that could be permitted within the county. In implementing the regulations, we've identified several issues, including competitions for permits and limited exceptions other than through a variance process. And based on those issues, we've been directed by the Planning Commission and the board to consider amending the setback requirements. The setback requirements, a draft ordinance was brought to the Planning Commission, recommended to the board, and the board remanded it back to the Cannabis Committee, and the Cannabis Committee provided direction on April 20th and to go away from the public necessity and convenience route and to maintain a 1,500-foot setback, but to create exception criteria within the county code. So staff has drafted an ordinance, and that ordinance maintains the 1,500-foot setback between retail facilities and provides that an exception could be made if the retailer is located in a community area, rural center, or large shopping center, and if the dispensary does not exceed 3 retailers within the community area boundaries or 2 within a retail center or shopping center. We have discussed with Public Health, who's here and will comment today. They are seeking an overall concentration limit or cap on the number of dispensaries to be added to the draft language. We have not included that because of the concerns with the competition for a limited number of permits and how that would be handled. But in general, the location requirements within the setback exceptions in front of you are directed towards our existing population centers within the unincorporated areas, places where the general plan promotes growth, and places where multiple options for convenience and shopping exist on large regional serving shopping areas. And so those were the 3 areas that would be part of the exception criteria within the draft before you. This map shows where the areas affected within the county would be. Pajaro, the areas in blue are your community areas: Pajaro, Castroville, Boranda, Fort Ord, and Chular. The areas in green are the rural centers, which be River Road, Pine Canyon, and King City, San Lucas, San Ardo, Lockwood, Plato, and Bradley. And then the large shopping centers would include the Barnyard and Crossroads Shopping Center, Mid-Valley Shopping Center and Carmel Valley, the San Miguel Canyon Prunedale Center off of San Miguel Canyon Road, and the Prune Tree Shopping Center. Those would be our large shopping areas. This map was brought to you previously. We have 3 existing conditions where there are competing permits within the county, within the 1,500-foot setback. There's 1 approved and 1 pending in Pajaro, which is a community area, and the draft ordinance would address that particular circumstance. The exception criteria would still need to be evaluated on its own through the public hearing process. There's 2 competing applications on Reese Circle north of Salinas in the Prunedale area. It would not address that particular location because it is not in a shopping center, rural center, or community area. And it would address the Carmel Rancho competing applications, as that is a large shopping center at the mouth of Carmel Valley. So it addresses 2 of the 3 existing competing application issues we have experienced to date. So with that, staff is asking that the Cannabis Committee provide direction on the draft ordinance, including the locational information, the limits within the community areas, rural centers, and shopping centers being 3 or 2, and whether or not to add a cap or overall density limit based on input from public health. Following Cannabis Committee direction, staff would make appropriate revisions and return through the ordinance process, including going back to the Planning Commission and back to the board for consideration. And ultimately, within the coastal areas, Coastal Commission would need to certify any changes. So that concludes my presentation, and I'd like to turn it over to Public Health to let them provide their input. Thank you.
Thank you, sir.
Chair Alejo and Supervisor Phillips. A couple of the considerations that you heard about there relate to a cap or a density limit, and the reasons for that from public health is it relates to the potential for exposure or excessive exposure for the more at-risk population. So one consideration could be where we have a limit if there's a disproportionate concentration of the cannabis retail facilities in or adjacent to low-income communities, which have been disproportionately impacted already. And we have in the past utilized census data to determine where we have communities that may be more priority communities for other initiatives like the Early Childhood Development Initiative. So I feel quite confident we could do the same thing again and come up with a very reasonable method for determining if there's a potential for disproportionate impact. Another example as it relates to potential language to put in comes from a model ordinance developed by Getting It Right from the Start, which is a consortium put out by the Public Health Institute. And what they do suggest as far as a cap goes would be that we have a cap on the number of total permits based more on the number of people, and we could look at the unincorporated area as where we have the number of people. And they suggest one retailer per 15,000 inhabitants. One potential issue with that is with the rural areas, you have very concentrated areas of people and they're very dispersed areas of people. But again, they have worked with a variety of jurisdictions to come up with a very reasonable way of coming up with a potential cap, which we could consider again. Now, the reason for that from a public health perspective would be if you get an excessive number of permitted facilities, you run the risk of then having extensive advertising and marketing for survival of those facilities. And then, as you know, from a public health perspective, you can then have a lot more exposure for, again, your at-risk populations, your youth, to then all the advertising that might be out there. And that would be a way of potentially, having some limitations on that in your communities. So those are two areas to consider as it relates to a cap or density limit, and we have expertise behind us to help come up with something reasonable to consider for the board.
And just a quick question, how would that work like in communities like Pajaro? From a Monterey County standpoint, Pajaro is a relatively small community, I think about 5,000 or 6,000 residents there, but they're in the Watsonville kind of area, so you cross the river. Does that get factored in?
We could definitely factor that in, definitely. We have, the census data is out there by all census tracts, and it's available to us, and we can create maps and create regions if we need to come up with density ideas for those areas.
Okay. Questions, Supervisor Phillips?
Thank you. Just looking at, you tend to see more of the dispensaries in the cities. And how does our proposed cap or regulation, because I know like Seaside has got a number in the queue there, in Salinas, I think so. Also, how does our regulations dovetail with the cities?
And we had a conversation with RMA about that. We're reaching out to the cities to get an idea of the number of permit applications they do have. And again, those census tracts are within the city, and we could potentially, again, come up with an estimate based on what is also nearby or adjacent in the cities, and work with the city planning departments as well on that.
Thank you.
Okay. Well, I guess any other staff want to present? Okay. Then we'll just open it up for comments from the public. Anyone?
Hi, my name is Dustin Garber. I'm a resident of Monterey County.
You could speak closer to the microphone.
Sorry about
please.
that. I just asked that when you're thinking about this, you remember that there are other requirements in opening a dispensary, like churches and schools. And when you look at a map of a city or a region, you're often going to find that the places that are allowable for a dispensary are shrunk down to a very small area. And when you're dealing with that, we still need to have some free market competition so that we have the best services available to the citizens of Monterey County. Thanks.
Thank you.
Good morning. Jason Retterer from JRG Attorneys at Law. We represent one of the applicants that's in limbo, Synchronicity Holistics, and they, on that slide you saw, they're the applicant in Carmel Rancho, Barnyard area. Really appreciate staff's efforts to develop the language. I know it's a long time coming. As I've stated in the past to this committee, I think from a policy standpoint, that an exception to the 1,500-foot requirement makes good sense for a couple of reasons. Mainly, it provides flexibility to the Planning Commission and to the board, if there's an appeal, to consider each of the projects on its merits without this kind of blanket prohibition. It's going to allow good projects to move forward, provided they meet the very narrow criteria that staff set forth. And then even if the retail project does meet that criteria, keep in mind that there's still a use permit obligation. They still have to obtain a use permit. That's a fully transparent process where they provide notice to neighbors, have a public hearing, and people can come out and weigh in on the merits of the dispensary at that particular location. So with that, I would just strongly encourage this committee to recommend to the full board this amendment to the ordinance. I think it makes good sense. I did see a reference in the agenda report about the ordinance going back to the Coastal Commission, or not to the Coastal Commission, but maybe conferring with coastal staff. I think for the inland areas, I don't see why you'd need that initial consultation. So hopefully the inland ordinance can go a little bit faster than the coastal, rather than pairing them together. And then also, I know the Planning Commission had a fairly extensive discussion of the setback. It went to the Board of Supervisors already. They made a recommendation to come to this committee for further direction. So if there was any way to get this back to the board without having to go to the Planning Commission, that would be preferable from our perspective, considering just the amount of time it's taken to get to this point. So those are my comments. Thank you.
Thank you. Anyone else? Okay, want to bring it back. Staff want to respond to the inland versus coastal, and also timeline. If it does go to Planning Commission, when will this come to the full board?
Absolutely. Thank you, Mr. Chair. Brandon Swanson, RMA Planning Services. Kelly Donlan's here from County Council. She may want to add a little bit more about the question of whether or not it needs to go to the Planning Commission. My understanding is, depending on the recommendation and what ends up happening with the drafting of the ordinance language, how different it is from what we took to the Planning Commission originally will determine whether or not it needs to go back to the Planning Commission. So I think that question is still up in the air. So that sort of speaks to the Planning Commission and the timing as well. The other thing that I wanted to just mention briefly, just for a order of magnitude, in the over year and a half that we've been accepting applications for cannabis businesses, we currently have 19 applications for dispensaries on the books. So it's not it just gives you an idea of how many we have in the county right now, total.
Typically, when we're processing inland and coastal ordinances, we would, in this case, we've drafted the inland version, are seeking direction from the Cannabis Committee on one set of draft ordinance regulations. We would do a similar exercise in the coastal zone, alert the Coastal Commission that this is our intent, have a conversation with them. But it takes a matter of an hour to draft the coastal version, or maybe a little more, and it goes together as a package usually within the county. And then at the point where the Board of Supervisors acts on the ordinance, then they become separated because we have to submit the coastal version to the Coastal Commission. So the board at that time would be adopting an ordinance inland and adopting a resolution of intent to adopt an ordinance in the coastal zone subject to certification by the Coastal Commission. So they really run parallel until that point, and it shouldn't be much of a delay in that case. And Brandon was correct that the planning and zoning law, it requires that if there's substantial changes to the ordinance, following the consideration and recommendation by the Planning Commission, that it go back to the Planning Commission, and the question of what is a substantial change is really the issue here.
Okay. And we'll have Kelly, Ms. Donlin.
Good morning, supervisors. In my mind, this ordinance has changed enough to require it to go back to the Planning Commission. The Planning Commission really studied the public convenience and necessity issue, and the language has, I would say, dramatically changed to justify it going back to the Planning Commission.
Supervisor Phillips?
Yeah, I think so. Just a little sideline. I noticed that the one that you said this doesn't impact is Recircle, but then I look at Recircle where there's 2 proposals in or applications in, is not in any shopping center or community area or rural center. Is that right? Yeah.
That's correct. I think what Mr. Spencer was saying is that the way that the ordinance is drafted right now, the 2 that it does cover basically means that there's a path forward for those where they could potentially find their way into the exception. The Recircle circumstance, it still would be precluded from getting that. Yeah.
Okay. So if there's no, I don't know, Supervisor Phillips, what you will in terms of what we move forward from staff's recommendation. I'm comfortable with staff recommendation. The question on whether we add a cap or density limit, I'm open to seeing what that looks like as well.
Yeah, I feel the same. There were frankly, some inequities or appearance of inequities when one person got there just days or weeks before someone else in an area. But in this big of area, it doesn't appear that we would be oversaturating the area. So, yeah, I feel, and this modification on retail setbacks is a much more defined, and it's not as nebulous as we initially had proposed. So I feel more comfortable with this this modification.
Okay, so with that, we have concurrence on moving staff's recommendation forward and also including what a cap may look like, because I think that needs to be a little bit refined, be more, but it'd be good to see what that looks like.
Okay, so Mr. Chair, if I could clarify then, so it's the 2 written exceptions, and then we will be taking some sort of formula of a countywide cap forward to the next step to see what the decision makers want to do with that. That would be a potential add-on then,
Yes.
essentially. Okay, thank you.
Okay. Thank you, Mr. Swanson, Mr. Spencer, for your presentation. So moving on to item number 3, Cannabis Program Strategic Plan, and we have our Program Manager, Joanne Iwamoto.
Chair Alejo, Supervisor Phillips, Joanne Iwamoto, Cannabis Program Manager. I'm here today to present the Cannabis Program Strategic Plan. The importance of the strategic plan sets the vision for the program, and some have compared it to that, very similar to a general plan. We began working on the strategic plan in early April. Many interviews, including interviews with yourselves, were conducted to understand the department processes, areas that have gone well in the past years, and then areas of challenge. The strategic plan is very important to the program because it brings together the 10 departments. We work together on common goals. We share processes, share challenges, and help each other find practical solutions. A big portion of that is the coordination and the collaboration. We entered into an agreement with Management Partners, Inc. to assist in the development of the plan, to document the plan, and to facilitate a one-day workshop. We had the workshop on June 29th, and all 10 departments participated, and the 10 departments are shown on the slide. We gained consensus on our mission statement, which is now on our webpage. And we developed 4 very broad goals to achieve in the next 3 years. And I'm here to really just to kind of give you a preview. I won't read each one and go through each one, but these are the 4 goals. They are broad in nature, but they are specific enough to help the program and the 10 departments to give them guidance and, and of course, to get agreement. A companion to the strategic plan is the action plan. And the action plan is really identified by the 4 goals, and within each 4 goals there are strategies. And the strategies are timelined, beginning with currently, beginning today or beginning now, and then most of them would be considered to be ongoing, and it does identify the lead person or the department. But I will say that for quite a few of them, the program manager is identified as the lead, but the person will not be working on its own. They'll be working with the departments. Just this is an example for Goal A, to support the lawful cannabis industry's efforts to generate economic development in Monterey County while being mindful of other local industries important to the well-being of the county. We have 3 strategies that will begin in effect as of now, and they will be ongoing. And I do have slides that continue, but I won't obviously read them all to you. As part of the strategic plan are the performance measures, and we've been working rather closely on the enforcement measures, but we have not gained agreement on all of them, but we will be doing so within probably the next month. The cannabis program would like to present this strategic plan to the full board, and we do have time on September 11th when the board returns. The program would like to provide quarterly updates to this board committee, if that is the direction, and as well as to the full board. And with that, this concludes the presentation, but I'd be happy to answer any questions.
Supervisor Phillips?
Well, I was on this committee since the beginning, and I don't think, and I'm the one that initially instituted, well, let's look about legalizing marijuana. I don't think any of us realized how many departments it was going to cross and how complex the coordination of all this. But you look at 10 departments across there, and we figured, well, we could draft a legislation, here we go. But especially in the enforcement and other areas, and enforcement has a broader, you look about ag, environmental health, they're all involved in enforcement. So I think it is important that we have someone in your position who's coordinating all this, and that we look to where we're going, look at our goals, and move forward in a strategic way, because it's really necessary. So I think we're moving in the right direction.
Thank you. And I saw that chart with all the county departments talking to each other. How do we, in terms of like public safety and enforcement, how are we also coordinating with our local fire departments as well? Because there's been like new issues, new concerns that on that question. I just don't know how we're including our fire departments in the county in that discussion as well.
So actually, the program has an enforcement task force, and we've met probably more frequently in the past 2 or 3 months, and the fire departments are actually part of that task force, and that includes other outside agencies when needed. They will participate, but they have been very supportive and collaborated with us, and I believe they are actually here in the audience today.
Okay. And that's why I just want to make sure that we're strategically including them in,
Yes.
in the dialogue and communication that throughout the year as we're developing our enforcement plan and just our strategic goals for the cannabis industry. The only other things that I think there's a lot of different goals and strategies mentioned, and I just want to just state them for the record. I think there's some other areas that we just got to also prioritize. So with all other great goals and strategies, I thought also just maintaining effective relationships with our state agencies as a goal with the Bureau of Cannabis Control and Department of Food and Agriculture and other relevant state agencies is an important goal, and we're like intentionally wanting to make sure that we have a strong relationship with the agencies that oversee the industry. Also, As a goal, I know during the discussion of taxation was also to hopefully incentivize expanded growth in the nurseries, and that just wasn't listed, and I think we should intentionally monitor that, and hopefully we're seeing as perhaps taxes are tax revenue is less because of the lowering of taxes, we can make some of that up as a goal by expanding in the nurseries over the next 12 months. I think also as a strategy, I think there was a need for us to periodically just look for areas of improvement, that we're constantly evaluating how things are working, and reflecting on that with all our county departments, and trying to improve how we're carrying out policy and enforcement in the county. Another thing was we did these town halls, got a lot of community input, but as part of our intentional strategy and plan, we should also take that into account every fiscal year. I mean, I think we already did it. We're not going to do it every year. We did it at the beginning to seek that community input, but that information should be part of our strategic plan, and we try to weave in what those community goals were every year as we're evaluating how we're using cannabis dollars, how our overall goals are working in the county. And I think that's important that we keep that as a central and important piece of our plan. I think other parts that we're already doing, but they should be listed, is also supporting the banking efforts. This year we supported, I think it was SB 930, which is legislation to allow credit unions to be able to deal with some of the liability and legal issues. But certainly we know that's another major area. Even though we're part of the Joint Powers Agreement with CSAC, which is working on the data part, there's another parallel track, and just supporting legislation so that in the future, hopefully we could see banking institutions here in Monterey County that are helping facilitate the growth of the industry within the county. And then lastly, I just wanted to say, I think just keeping it as a goal that we hope that Monterey County continues to be a statewide leader in cannabis. You know, we're competing against other coastal counties, the Emerald Triangle, but certainly I think as a policymakers, we want to certainly keep our county as a leader when it comes to local and statewide policy. And I think it's nice to have that enumerated as a goal as well. So those are just my thoughts, looking over the many different good strategies we have in this plan.
Okay.
Supervisor Phillips?
I'm glad you mentioned the fire, because we were halfway down the road and brought everybody in before Chief Urquides and North County Fire said, well, no one's talking to us about it. And so I'm glad we're including fire in the coordination.
Yes.
Okay, and thank you.
And we'll open up, and is there any comments from the public or from our fire departments? Thank you for being here today as well.
Thank you, Chair Alejo and Supervisor Phillips. I think Joanne's position has been key to the conduit, the liaison to those fire agencies. As we know, Monterey County is very diverse in fire protection, everything from volunteer agencies to state agencies, local government. So again, the one thing we do want to point out, I know there's been frustration by the applicants. Just for our area, for example, we have 300 state permits. And obviously, we just didn't have the staff, I think, with the cumulative amount of square footage that is in our district. And I know North County has a tremendous Aromas, who's also under the contract of CAL FIRE. So these meetings that Joanne have been putting together, unfortunately, like anything else, especially with county staff, is we're short-staffed. We're struggling just to, as retirements occur, to bring people into Monterey County to work. And so hopefully the applicants know that we're doing everything we can to process their permits in a timely fashion. But we do thank you for the outreach, and like I said, the funding and creation of Joanne's position has been the key. Thank you.
Thank you very much. Anyone else? See none? Okay. All right.
All right.
So do we need to adopt anything here?
And to
adopting
give-
this plan?
And direction to go to the full board. And I will incorporate some of these comments.
Okay, so then by consensus, we'll adopt this strategic program, cannabis program strategy plan, and have it be forwarded and agendized for the full board meeting.
Okay, thank you.
Thank you. Okay, now number 4, cannabis permit status update by Brandon Swanson, again.
Thank you, Chair Alejo, Supervisor Phillips, Brandon Swanson, RMA Planning Services Manager. This is just a brief update. There's no presentation to go along with this. You were sent a memo just to give sort of the status of the world of permitting right now. So I wanted to hit some of the highlights there and see if there's any questions from the committee. A couple things of note, there's been 2 more DRC applications received in process, so our total number of ultimate use permits we could have has gone up from 102 to 104. The use permit applications that we've received has gone up from 27 to 42, which is telling us that people are starting to get their use permit applications in. That's good. That's what we want to see. I think that's an indicator of the memos that the RMA has been sending out and reminding people and working with folks in the industry to get them in here. To date, there's been PC hearings of 11 items. That's up from 8. 6 of those cultivation, 5 dispensary, with 1 more actually happening this week. On Wednesday, we have 1 cultivation operation that's coming forward for a use permit. We still have 62 use permits outstanding. And the interesting note on this is, as you know, as of August 1st, the county has a deadline of anyone who is temporarily operating needs to come in for their use permit, have that use permit application in, or they will fall out of good standing and will take immediate action on the site. Of those 62, only 14 of those are currently operating. So we've got 14 out there in the world that have a temporary authorization. They've said they're working on their use permit application. We have not seen it yet. So as of August 1st, those 14 would be immediately out of good standing. We'd take action, enforcement action on. I'm happy to report, though, that I think about 5 or 6 of those right now have appointments to come in and submit over the next week. So I think that number is going to continue to go down. Should be a pretty small number come August 1st that we'd actually need to go out and visit to take action on.
8 more days.
It's
Go
right.
ahead.
Question, you said 62 outstanding, and what'd you say, 14 were?
14 of those. So there's 62 that have gone through the DRC. They've received their comments. We have not received their use permit application yet. Of that 62, 14 of those have a temporary state license. So they've been in good standing.
Are the other ones operating, though?
No, those would be, to our knowledge, those would be sites that have no cannabis operations on them. They're just looking to entitle property to do that business. Yeah. And that's the end of my update. So if you have any questions, I'm happy to answer them.
And, any other questions, Supervisor Phillips?
Well, it's just looking at with the question with the crunch looking like it's going to be coming, the question was raised whether we're going to be able to process all those before the Planning Commission in a timely fashion without, with being fair to everybody and with the crunch that they may fall out of compliance if they can't get into the queue fast enough. So you got any?
Thank you for the excellent segue, actually, into the next item. RMA is looking at ways, at the direction of this committee, to try and streamline our process. One of those is the next item we're going to talk about, is potentially turning the use permit via ordinance into an administrative permit, which is still a discretionary permit, but it does not have the public hearing, the presentation, the additional steps. It's done in the RMA and signed by the Chief of Planning. So that's one thing that we're looking at right now. Also to that point, the 62 that are outstanding, this is a bit anecdotal, but we've heard even from Chief Urquides in some of our meetings, we anticipate that a number of those will just not come in when we actually go out to them and say, are you actually going to submit your use permit? Are you still wanting to do this in the future? We think that some folks will just decide, this business is hard. There's a lot of people already with their foot in the door, and they may just opt to withdraw their applications. We don't know what that 62 is actually going to turn into at this point.
Okay. We'll open it for comments from the public on the cannabis permit status. See none? We'll deem your report accepted by this committee, and we could just move on to item number 5, the use permit, coastal development permit, and administrative permit comparison.
All right, thank you. So currently, as I mentioned, not yet, well, I'll tell you when I spoke. Currently, as I mentioned, all cannabis use permits, coastal development permits in the coastal zone have to go to the Planning Commission, which is a public hearing. To date, 11 have been heard. That leaves in total 93 that are somewhere in the process. We've either received a use permit from them or we have not, but there's 93 out there still that will need to be processed in some form if they all come to fruition. With RMA recently pressing to get those applications in, and we're starting to see that surge come in, we could have a large number that would cause an issue with all of the other land use items that we have to take for a public hearing to the Planning Commission. There's a lot of stuff that the county has to process through public hearing other than cannabis items. So knowing that, we thought about ways to streamline the process. And I want to note that the Planning Commission to date has not been a delaying factor in this. The agenda has not been a delaying factor. As I said, we've only processed 11, but we're just trying to read the writing on the wall and see what's coming down the road for us. The additional wrinkle with this situation is that as of right now, the way the state laws are written, come December 31st, the state will no longer be issuing extensions to temporary licenses. So any of those operators out there in good standing who have their use permit in but are stuck in the process of getting their use permit through our system, not only the use permit but also the business permit and the business license, if they don't have all their permits in hand by December 31st, 2019, or 2018, basically January 1st, 2019, they won't be able to operate anymore, potentially. That's the way the laws are written right now. So if whenever their extension runs out, if it's the ultimate date of March, which would be 3 months past January, they would potentially have to stop all their operations if we can't get all of their permits done. So again, RMA, at the direction of this committee, looked at ways to streamline this process. So one solution would be to change the ordinance requirements, which currently require that use permit, coastal development permit, to an administrative permit. And if Megan, could you put up the slide for me, please, on my screen? Thank you. So we prepared a side-by-side, and the biggest thing to note here as I walk through this is that the level of review by the county, both RMA and all other land use agencies, remains the same. When an application comes in for an administrative permit, it still gets packaged up in what's called our interdepartmental review, or IDR. All the application materials go out to the land use agencies, water resources, fire, environmental health. They take their 30 days to review the project for completeness or incompleteness, get more information if they need it. And then all of that comes back to the Planning Commission, or to the Resource Management Agency for compilation. So the level of scrutiny and review remains the same. The difference then happens at the decision-making level. For administrative permits, the staff report is written and a resolution is written. However, it's decided on by the Chief of Planning. With the current process, the staff report is written, a resolution is written, a presentation, PowerPoint presentation is prepared. It has to be put on an agenda for the Planning Commission, which only meets twice a month right now, and then there has to be a public hearing. So there is a bit of time that's taken up at the end compared to the administrative permit process. It's still a discretionary permit process as an administrative permit, and the other thing to note is that when we process administrative permits, there is a public notice still. So if someone from the public has concern about a dispensary or a cultivation operation, they would have the opportunity to request a public hearing. So if we were to receive that request, it would be elevated to the Planning Commission for a public hearing. To date, there's only really been one point of contention on these cannabis items, which is the setback issue that we're all familiar with, and we're working on an ordinance right now to try to address that.
How does that notice take place if it's going to be done through the administrative process?
The same way it does with the use permit process. It's newspaper at the site and and mail. Thank you. I just lost the third one. So there's a 300-foot mailing list that goes out as well. So same noticing process as the use permit.
Thank you for that.
And so that would be the other, I think, part to note, and council may want to speak to this a little bit more. Because it's still a discretionary process, we retain the CEQA exemption that exists. There's still a discretionary decision at the end of the permit, so it's not foregoing the CEQA process. In order to implement this, we really would just be bolting on the action to an ordinance update that we would be taking forward with some of the other updates we'd be doing right now. So it would fall in line with that process as well. And so RMA suggested this would be an option to streamline the process.
Great. Any comments?
Just a question. So far, it was mentioned in your materials that there hasn't been much contention other than the dispensaries, the cultivation hasn't been hotly debated before the Planning Commission?
That's correct. The one issue that's come up, and I didn't highlight it as a major issue because it was resolved and easily so, was the odor thing, the odor issue. And we've actually created a standard condition of approval. It was already in the ordinances to sort of quell the odors coming out of these cultivation sites, but we've added additional conditions of approval to make that a better situation.
And about either way, this wouldn't be going to the Planning Commission or the Chief of Planning until all the agencies have signed off and have concurred that it meets all the qualifications of the project?
That's correct.
And about when that's done, about how many of these can you be heard in one session at the Planning Commission if it's kind of become routine? I mean, could you have 20 or 30 a day?
At the Planning Commission, currently, because there's no consent agenda at the Planning Commission, they have to be heard on public hearing, and so there's a presentation, there's public comment, there's comments and questions from our typical process. We have not seen a big wash of these yet. As I said, we've only processed 11 through. But a typical day at the Planning Commission, a big day, is between 6 and 8 items. So I can't see processing 20 through. The other thing to note with the administrative permit hearings is we currently have it on a twice-a-month schedule as well, but because it's decided by the Chief of Planning, we could go every week if we wanted to. We can easily change that without special meeting notices because the Planning Commission is scheduled out through the end of the year. Any additional meetings of the Planning Commission are considered special meetings and they have to be scheduled.
And if then the appeal process would be from where if it was the Chief of Planning that was making the decision?
Right, and so, thank you. So the administrative permit process, the way it works is before the decision is made, we send out a notice saying there is going to be a decision made on such and such date. You have until this date to request a public hearing. So on that front end, before the decision's made, it's a request for public hearing. It's technically not an appeal at that point. So we would elevate it to a public hearing and we would have the public hearing. After the decision is made, just like with the Planning Commission, there's 10 days to appeal the decision. So that would be an actual appeal going forward. So there's actually, in the administrative permit world, there's actually 2 opportunities to get it to a public hearing.
Okay. And the appeal would be to where?
The
Planning
appeal,
Commission or the board?
the appeal would be to the Planning Commission.
Thank you.
And I'm glad staff looked into how we can make it the process more expeditious, and also taking into mind the deadlines by the end of the year, what needs to happen before then. But also, is this are other counties that have cannabis industry, do they have a similar administrative process for permitting as well?
There are various processes throughout the state. Some jurisdictions actually process these as ministerial permits, depending on what sort of CEQA work they've done on the front end. But there's the wide variety from administrative permits all the way to use permits like we're doing currently right now.
Okay, great. Now let's open it. Any comments from the public on this item? See none. Okay. Supervisor
I guess my other question, maybe to Carl, but if we made this decision and sent this to Chief of Planning, what's the ramification as to other non-marijuana? Are we having a precedent for non-marijuana hearings about planning issues? Do you see any precedent, it being precedent-setting in any regard?
No, I don't see it being precedent-setting. So I'll add on a little bit to what Brendan was talking about also, and I think some of the questions that I heard from the committee. So all the projects can't move forward until they're complete, and they can't move forward if they have a code violation on the property. And we're interpreting that to include, for those that are in operation, they're required by code to pay their taxes. So if they haven't paid their taxes, they don't get to go to hearing. So that does kind of regulate as far as the applications getting to where they need to go to hearing. We have made the decision for economic development purposes that projects are, need for affordable housing, those projects do have a priority level for getting processed. So in this case, if we were to have all 60 all of a sudden become complete, we would shift our resources to make these priorities to get through the process. I don't think that's precedent setting. We're doing it not just for cannabis, but for economic as well as affordable housing projects in general.
I think, Mr. Chair, if I may also,
Yes, sir.
another thing to note about administrative permits is it's a process that we currently have in place for processing land use entitlements. It's just at different levels. So it's not something that we're creating simply for cannabis. It is a land use approval tool that we have right now.
Okay. So what's the timeline? Does this, if we decide to support this administrative process, do we still need to take it and have it approved by the full board? Because now we're going into summer recess. We don't have our next meeting till August 28th.
Correct. So the process would be similar to that of the setback ordinance. So we would go and make the changes to the ordinances. It would have, because it's Title 20 and 21, the land use ordinances, it would go to the Planning Commission for recommendation to the board. So staff would intend to have those in front of the Planning Commission, then go to the board. And obviously the coastal side would then go to the Coastal Commission, just like with the setback ordinance.
Okay. So,
I feel comfortable with that. There's obviously going to be some urgency here, and I feel comfortable that if they have to be in complete compliance, including no violations and taxes paid, and all the various departments have signed off on it, I feel fairly comfortable with
Yeah.
the process.
so I guess we'll deem this accepted and forward it to the Planning Commission and to the full board. Even once it's implemented, even if it's September, then you're talking September, October, November, December, 4 months, so hopefully that could really help in those last few months of the year. So with that, we'll deem it accepted and forward it to the
Right.
Planning Commission.
Thank you.
And full board. Okay, that was our last item of business. Let's see here. Okay, we're gonna open it up for public comments for anything not on today's agenda. Would anyone like to speak on anything not that we didn't speak on today before we close this meeting? Seeing none, I think our August 24th regular meeting has been canceled, and we have our next special Cannabis Standing Committee is going to be on August 8th in the Monterey room. Okay? With that, we'll adjourn this meeting. Thank you, everyone.